Alright, so this way people news one more time at it. Okay, never look straight forward, always look around and be able to protect yourself by any means necessary. Alright? Um, so I did a video yesterday, my last video before this one, right? Of an accident. So my mistake, um, it was the pickup, it had the markings and all that kind of stuff. Now, when I went in there, I also talked about how both parties broke transportation codes. But last night, news came on. Remember when I told you because of the DWI, everybody's going to look at that case itself. Now, that being said, hearsay, Bob talked to other people that kind of knew all the parties and had my bipartisan thing looked at because I didn't really know none of them, right? Allegedly, everybody has some form of DWI. You know, whether it was drug, whether it was alcohol, whether it was this, whether it was that. All right. So all parties was involved allegedly had this. Okay. But due to the young nature, they're going after the other one, which I'm led to believe and do believe that there may have been past criminal things. So they're looking at her more than the others. Now, on news, what they did is directly related, saying that she was in fault. That couple of kids, youngsters, wasn't really one minor, but a couple of youngsters passed away due to a DWI and all that kind of stuff, right? So they led to one party, okay? And they never brought up the youngsters ran the stop sign. So, that being said, since it's on TV with the whole Abilene area, the Baird area, Clyde area, all these areas hearing this, she's not going to get a fair trial due to all the negativity and one-sidedness on this. So right from the start, she's not even going to have a fair trial, y'all. I am led to believe and do believe that her case, particularly, should be in a totally different jurisdiction due to lack of having a fair trial. Even the news specifically put her as responsible when the other party ran the stop sign. So as a cause and effect of actions, yes. However, there was a stop sign, it was ran, allegedly, which caused the initial accident. I am led to believe and do believe. I'm not an attorney and not giving legal advice, okay? Just my opinion. And that's it. Now we're going to go back into this guy here of how to go through remedy, but every time he turned around, nobody's giving remedy due to corrupt official magistrate, judges, alleged judges. I'm led to believe and do believe they're all operating in a magistrative party. Okay, so even if they're judge, they could step down and become a magistrate. So one and the same, but since you are acting in a administrative, the judicial's gone. Okay, so you can file claims on that same judicial judge when it acts in administrative, right? It don't have that 11th Amendment qualified immunity, right? They waived it as soon as they dropped down to administrative. All right, let's go.
If you ask for it. If they don't have authority, any action they take is not only void, it's likely also criminal. Here's the definition of disgorgement from Webster's Dictionary of 1828, which I've heard was adopted by the U.S. Congress as the official definition of words and phrases used in the U.S. Constitution. At that time, to disgorge meant to, quote, eject or discharge from the stomach, throat, or mouth, to vomit, end quote. Notice it says nothing about a type of penalty, fine, forfeiture, restitution, or any other known remedy at law or equity to be paid for committing the public offense of not having a professional license. Let's look at the statute involved.
Let's stop right there. Remember the key words he is using. At law, in law. But there's at law, in law, of law. Most courts are operating of law, which we talked about before. I'm of my dad, but I am not my dad. Okay? So of. It's a very tricky word that we got to actually fine tune the usage of. No pun intended.
Business and Professions Code 7031B to see if disgorgement is found there. It says, quote, a person who utilizes the services of an unlicensed contractor may bring an action to recover all compensation paid to the unlicensed contractor for performance of any act or contract. Disgorgement is clearly not there either. So then where's the judge getting the authority to order disgorgement in his minute order? He noticeably doesn't bother to tell us what it means or where his authority comes from to order it. But it gets even stranger. The same judge later signed a judgment order, and instead of saying disgorgement, it now says damages. So which is it? Disgorgement or damages? These are two very different remedies.
And when you find a description like that, you need to call them out. I, per se, when I call it out, as absolute, vague, ambiguous, absolutely. That way there is no misunderstanding what I am telling them. Okay?
Reference, the word damages refers to an actual injury to person or property, and the judgment order itself is the final determination, not the minute order. So if in fact I caused actual harm resulting in damages, we should expect to see some serious evidence of injuries in the case amounting to nearly $1 million. But guess what? There are none. The entire court reporter's transcript is found in Exhibit A4 if you'd like to read it. There's not a single piece of evidence presented at trial that I caused any actual damages by allegedly not having a license. The plaintiffs never even made a claim for damages. What's going on here, which we'll dive deep into in Part 2, is that there's a presumption in play that anyone who acts as a contractor in California is presumed incompetent or dishonest, and thereby anything they do without first obtaining a license results effectively in a total loss without any evidence of damages. So where's the authority to make this order? Where's the authority to presume me incompetent or dishonest without a judicial determination of my rights? In other words, where's the evidence? And how could it possibly be that the licensing board found me competent as a qualifying individual for a general contractor's license, but then somehow I was magically transformed to be incompetent when it was alleged that I didn't have a license? After more than 6 years, no one can produce the authority for any of this. This is how legislators and judges manipulate words, phrases, and evidence under the look or color of law to ultimately commit robbery, treason, and other crimes. In my case, and many others I've witnessed, when you bring these egregious abuses of authority to their attention, they refuse to hear you and refuse to take remedial action. As I shared, my case has been before 27 state and federal judges, and all of them refused to correct the clearly insane and unconstitutional judgment. Because Darren refused to fully investigate and resolve the definition of these words that were each an issue, it became impossible for him to make a full, fair, and impartial determination of whether there was any probable cause, just like the cop that refused to turn around to acknowledge the bank robbery was occurring. Instead of doing his own full, fair, impartial, and independent investigation to discover the truth, he relied upon the same acts of deceit the judges used, namely found in the Court of Appeal opinion. If you can believe this, the Court of Appeal opinion affirmed the Superior Court judgment, finding it was for disgorgement, not damages. When I challenged disgorgement as being punitive, they found all my claims were meritless. Darren apparently relied on the Court of Appeal opinion, even though I gave him evidence the justices weren't telling the truth. The evidence I provided is a copy of a recent U.S. Supreme Court case where the court defined disgorgement. He refused to apply that definition to the judgment in my case to see if the two matched up. They obviously don't. The case I gave Darren is Lew v. SEC. In the case, Clarence Thomas addressed the precise issue I brought to Darren and every other police officer. Thomas said, quote, "As an initial matter, it's not even clear what disgorgement means. The majority's treatment of disgorgement as an equitable remedy threatens great mischief. The term disgorgement invites abuse because it is a word with no fixed meaning. Abuse is an understatement. This single word is being manipulated and used to conceal excessive, cruel, and unusual punishment to ultimately financially destroy countless people and their businesses." Of course, I presented all this to Darren, but instead of doing his job, he repeatedly told me this isn't a matter for your local police department and to return to the court system that was perpetrating the crime and covering it up. But this just isn't happening here in California. It's across the nation. A similar abuse of the word disgorgement just happened in the New York civil fraud case involving Donald Trump and the near $450 million in disgorgement that was ordered against him. I made a separate video about this called "Is Donald Trump Being Robbed?" If you'd like to check it out, it's on my channel, or the link is below. Another case I gave Darren is the case of M.W. Erectors from the California Supreme Court. Upon analyzing the statutory intent, the court determined that the statute imposed a stiff all-or-nothing penalty, not disgorgement or damages, a penalty. Now might be a good time to share with you more about how the judges are committing the crime in these cases in the same way I shared it with Darren. What happens is, so like let's say you hired me to build your house and you gave me the $1 million. Well, I went out and bought the $1 million in materials and hired the laborers and paid them, and now you have $1 million home. So the statute says, don't take into account what's already been returned with all the labor and materials. Make them pay another $1 million. So I already gave the money back to my clients by building them a custom home. And then the judge ordered me. That might be the matter of law. Exactly, Darren. If I already returned the $1 million like the statute says, the judge has no authority to order me to pay another $1 million. But unlike what Darren said, there's no debate about the matter of law of what's going on here. We have words that describe it perfectly. They are robbery and treason. But instead of using those terms, the judges are covering it up by calling it disgorgement. And the cops are helping them do it by refusing to act as a check and balance. In my appellate brief, I cited an Arizona Supreme Court case addressing these obvious issues. The court said that a rule of total disgorgement, regardless of any benefit conferred on the victim, may lead to absurd or troubling results. Duh! It went on to say that when determining the proper amount of restitution to be paid to a victim, consideration should be made for the value conferred on the victim, and that restitution should not compensate victims for more than their actual loss. In a concurring opinion, Justice Andrew Hurwitz, who clearly has sane functioning faculties, stated that, quote, "If the restitution statutes are read to require that the amount paid is invariably the measure of restitution, an untenable result would obtain. A homeowner who received flawless work from an unlicensed contractor would be refunded the full amount paid, but would nonetheless also retain the work performed. It is impossible for me to view such victim as having suffered any loss, economic or otherwise."
Alrighty, video getting a little long. Let's go ahead and stop it there. So certain things may come up. Now my next video is going to have the same deal of criminals of the government branches in a city doing the exact same thing here in Texas with C.J. Grissom and all that. So I'm going to do that one next because it coincides with what I'm telling you in this, right? Or showing you in this, okay? But there's going to be a few more of these with him because we're going to be walking through the steps. I just wanted to show you that it is happening in other places, okay? This is We the People News. Till next time, bye y'all.